Welcome to S.J. Boyle Wealth Planning. My name is Sally Boyle. I'm the founder. And our conversation today is about the 5 common mistakes that we see in estate planning. My guest is Renee Harvey, counselor at law at Legacy Counselors North, more recently known as Caldwell Law here in Lebanon, New Hampshire. And she's worked in New York, Vermont, and New Hampshire, the legal system since 1990. She's a graduate of the Vermont Law School, is licensed in New Hampshire and Vermont, and her practice focuses on estate planning and estate settlement, assisting clients with making informed decisions in those areas. She is also a Respecting Choices Advanced Care Planning Certified Facilitator. That's a mouthful. And she's a certified mediator. Renee also serves on the New Hampshire Bar Association's Dispute Resolution Committee, as well as the Patient Choices Vermont Advisory Committee. And she's a lecturer at a lot of local institutions, so she's a busy woman, because she also is the managing partner at Caldwell Law. A lot to do, huh, Renee?
Every day.
Every day. So today we're going to talk about the 5 most common mistakes that we see in estate planning. And we see more than these, obviously, but these are the ones that we think are best informative, most impactful to share with you, because you might actually see yourself in some of these. But before I do that, let me see if I can set this up properly, Renee, because our roles are very different. Renee is the person who executes the documents. She does all of the legal things. And I guess I like to think that we do everything all around that as financial advisors. So, and it's important to us because for several crucial reasons, because most of us think about estate planning as controlling our stuff when we die. And I think we think about it as kind of taking care of your loved ones through this process. Because when you think about it, at your death, you're gone, right? And your family is already dealing with a whole lot of missing you and the hole in the family. And so when you think about that, do you necessarily want them have to be dealing with all of the other things like organizing an estate or facing a court system or even dealing with any financial concerns at all, right? So when we talk about estate planning here, what we think about really is the legal terms. I mean, we understand wills, trusts, and probate and all that stuff. But our focus in working with clients is making sure all of the details around the documents or the legal things are taken care of as well, so that should we lose a client or in our family loses a family member, we don't have to face those families with the mess that we didn't help clean up. And so we take it very, very personally on the estate planning. Part of the reason I like to work with Renee is her firm does the same. I work with a number of attorneys in our estate planning process as we implement with folks. And your firm does a very good job of taking care of all of the details around it. So talk to me a little bit about your all's view of estate planning.
Yeah, so we look at working with a client on their estate planning as an opportunity to actually collaborate with their other advisors, such as yourself. So a financial advisor, their accountant, their CPA, we look at it as a way to get all of their advisors on the same page so we can create the best plan for them, because each one of us will bring something different to the mix. The financial advisor is really important in terms of assisting us with capturing in documents what the wishes, the goals are for the client. Their confidence, their peace of mind, and that those gifts will be made come from you and all of the work that you do with them about looking at what they have, projecting it into the future. So when we work on an estate plan, we don't want it to just be about the documents. That's a really important part of it. It's 50% of it. But the other 50% is making sure that their assets and their financial advisor is involved in their planning to help us align their assets with those documents so that those documents can really do what they're intended to do, which is direct those assets to the right people at death. So we feel very strongly that clients need to be educated on a more holistic approach to their estate planning, which is the exact reason why, Sally, we love to work with you, because that's exactly what you do. You do encourage the client to take a broad look at their planning and everything that comes with it.
Yeah, and that's so important. Because the estate planning filters into everything else as well. So then today, what we're going to talk about are 5 mistakes that we see, and Renee's going to give us the legal framework of these mistakes. And what I'm going to try to do is just follow up with what I've seen in client interactions and in the real world. So we're going to try to give you the legal side of things and the storied side of things. So let me start with the first one, if I can. I guess it's misinformation. That's the term that we both agreed on, right? And this is one where folks think, I don't need estate planning. I'm not rich. I don't have a lot of money. I don't, I don't really need an estate plan. My spouse is going to get it first, or my kids are going to get it second, or my kids are going to get it first, depending upon the family situation. And so when people hear estate planning, they assume that they have to be wealthy, right? And that's not the case, is it?
It's not. It's about taking control now so that you know what's going to happen later. And so one of the things that you mentioned, I don't need an estate plan because I don't have enough, is sometimes what people think. I don't have enough to put into a trust, or I just have my house. And it doesn't matter how modest an estate is or how sophisticated an estate is. What we're doing with planning is we're making sure that what's important to you gets to whom you want it to get to, rather than somewhere else. So, for instance, if we don't look at the estate planning carefully in terms of beneficiary designations on assets, if you say in your estate plan, it's going to my children, and you created that asset and the beneficiary designation years ago before you had children, and it says it goes to your brother, that asset is going to go to your brother and not your children. So it's important to look at your planning and the assets, as I mentioned before. And no matter if it's one asset, a checking account, or multiple assets, you have an estate plan that needs to be put into place. It may not be going where you think it will go. And that's the example of the beneficiary designation. But there are tools that you can utilize for assets, like beneficiary designations on accounts and other tools that we use, to avoid having to go through probate if that's something that you don't want your family, your beneficiaries, to go through. Because with certain assets, if they're not properly positioned with a certain deed or a certain beneficiary form, they very well may end up in probate. And that could be a vehicle, a
Yeah.
small checking account.
Yeah, no, it's really true because here I am, the financial advisor. I made that mistake myself with my mother's estate settlement. Everything was just hunky-dory, in terms of simplicity. And there was one checking account I had gotten a little lazy on and not moved it fast enough. And so we spent a lot of time probating a $30,000 account. So it's really, really true. It's taking a look at everything. And that includes vehicles, all of that, doesn't it? Yeah.
It does. It even incorporates what we call our personal property, the things inside of our homes.
Yeah, exactly. Exactly. So nobody's too small, and I want to give a little bit of a story on this too, because it's the things around our stuff too that are also sometimes the most difficult decisions to make. And so I had clients who we had a great estate design put together before they actually went to execute the documents. But the most difficult question for them was who their guardians were going to be of their children. They were a young couple, 3 young kids under 4. And so their family situation is very unique. And so those kinds of, it's even outside of our stuff, I think sometimes that is also somewhat challenging, the guardianship. And I want to ask you about this, Renee. I mean, I read this recently where, even young college students maybe need to have a medical power of attorney so that if something happens to them health-wise, now they're adults, right?
Mm.
And their parents really don't have access. Do you ever recommend that?
Absolutely, and particularly because where we're located, we are in a college town, so to speak. Once that child reaches the age of 18 and they're no longer a minor, the parent doesn't, even though the parent might think that they're still a dependent, and maybe the
Right,
child also feels
right,
that way, that legal change from being a minor to no longer being a minor actually removes the parent from being able to help the child. So a
right,
financial power of attorney so that the parent can speak with the college, let's say.
right,
A healthcare power of attorney in case something happens to the child while they're at college, being able to communicate with the medical team. Those two documents, at the very least, are very important because otherwise there will be a privacy wall between the parents and the child who is in real need of help. And without those documents and a need for help, a guardianship would have to be taken out over the child who's an adult, but we'd have to take it out in the probate court as an adult guardianship to get the same exact powers that are in those medical documents and the financial power of attorney.
So even that's the kids who have nothing, the college students still have, it would be best for the family to put together something as simple as those proper documents to allow, because you really don't know what's going to happen, and they're simple documents to execute. So
Yeah, and it's just access to information really for the parent who may be out of state, um, to find out what's going on. And without it, it will be a very frustrating
yeah,
experience, I would expect
yeah,
for most
yeah.
people.
We had experienced that with one of our kids. Now, the second mistake we see, and I think you referenced it earlier, was asset alignment, right? We have these beautiful documents written, maybe a wonderful will or a terrific trust, but somehow the assets are not aligned with it because there's different ways that assets are distributed during an estate plan, right? You referenced beneficiary designation, but it's also titling. So speak to that a little bit.
Yes, the biggest, and I think this really goes to our first question of misinformation too. The biggest, I think, surprise for some people is that because you create a will and you say who you want to receive from you, um, doesn't mean there won't be any probate. It just
Okay.
means you captured your will, you captured your wishes in writing in a will for distribution to those individuals or those organizations that you're leaving to. It doesn't mean there won't be probate. Probate is focused on one particular type of asset, and that's an asset that we die owning in our name alone. And I'm going to put a little asterisk after that sentence. The asterisk is I die owning it alone in my name with no joint tenant. Okay, so
Okay.
like a joint owner on a house that's surviving. It is not a beneficiary driven asset like a retirement account or a life insurance policy, or it is not titled into the name, into the a trust's name. So those are the three asterisks. No joint owner, no beneficiary designation on it, and it's not owned by a trust. That's the only thing probate is concerned about. But just because you put it in your will doesn't mean you've bypassed probate. You've just
Yeah.
written down your wishes. And the same goes for a trust, which is equally as confusing to people because they think creating the trust automatically all their property is in it, and it's
Yeah.
not.
Right.
Each asset has to be titled so that the trust has control
Yeah.
of it, from a car to an account to your house.
Right. Right. And that's what we see quite a bit. I'll give you one story where I had clients who executed a beautiful trust.
Mhm.
And they had some Roth IRAs with me, and what they were doing was paying for their grandchildren's education out of the Roth IRAs. And they wanted to continue that if they died. And so within this beautiful trust, they had a second trust created that was their educational trust,
Mhm.
and they wanted to continue to use the Roths for that purpose. And so I see this beautiful trust and I read the document and I'm like, yes, but the beneficiaries of your two Roth IRAs are each other. You know what I mean? So in your death, it's not going to go. I mean, this is a great idea to have the trust in your trust document, but if we don't change the beneficiaries, it doesn't matter because the financial institution is going to read who the beneficiary designation is, and that's who they're going to write the check to,
That's
right?
that's exactly
Yeah,
right.
exactly. So we had to, we shuffled things around a little bit, but it was interesting. And this is where I'm saying you sometimes need to encourage if they aren't doing it willingly, not willingly, but taking initiative on this. This is why I say Renee's firm does a very good job because they don't just execute the document, they contact a financial advisor like me because I'm the one who needs to make
Mhm.
those changes at the financial institution that holds the assets, right? And so we did do that. When I read the trust document, I was like, wow, well, this doesn't work. This is not going to work if we don't change the beneficiary designation at Schwab to your trust account. And so we've had some personal experience with that, and it's not unusual. I also have other clients who, again, executed a lovely trust. But I said to him, what about that? He's got collectible cars that are worth hundreds of thousands of dollars. And I sort of said, well, okay, but what's going to happen with these cars? And he's like, well, my trustee will take care of it. And I'm like, well, no, not if you don't title it to the trust. So just because it was a collectible and outside of his thinking of what should be in the trust, my home should be in the trust, or maybe my investment account should be there. There are other things that you have to give some consideration to as well if they have value. Um, you know.
Yes, and a point that you brought up, Sally, is if it's not in the trust, um, and it's an asset, remember that you die owning in your own name. it's got to go through probate to get
Right,
to the trust. And that's a
right.
two-step process that doesn't need to occur. We have a trust, everything should be put in there, which is administered privately and outside the court's, just, outside of the court's eyes. It's not through the probate court process, administered privately. Now you've got two steps if we don't get it in the trust
Yeah.
rather than just one of putting it in the trust now and having it be privately administered.
And that really frustrates the original intention of the trust. I think
Yeah.
most people, just for explanation purposes, most people want to have trusts because they avoid probate. In
Yeah.
other words, the transfer of the assets go from your trust to maybe to your successor trustee, whoever that might be,
Mhm.
right? And so the person who actually derives what happens in your trust document is that trustee. And so versus your will that would send assets that are in your name through probate, and it's the probate court that would actually execute your intentions. So, but probate, I can tell you, is not fun. And so that's why most people do trust. I mean, they may do it for privacy too, because an estate that's settled through the trust is more private than a probate process. But usually you're trying to avoid probate. And so to leave those assets outside, that frustrates generally your entire intention around trust, right?
It does. And people generally, for general estate planning purposes, put trusts in place to accomplish one of these two goals, or maybe both of them, to avoid probate. Maybe that's their whole goal, and the trust will just distribute out outright, as we say, or it is so it can manage the inheritance for
Yeah,
a beneficiary if there's a need to. So
yeah.
it can do one or the other or both, but it is a great tool to help with probate avoidance if that is high on your list.
High on the list. So that leads me to the fourth one, because this I have a great story on this one where you were just saying you are giving the trustee the responsibility to manage the assets, right?
Yeah.
And so sometimes we're doing that. It's interesting because our children are young, right? And so our kids are not mature enough to manage the money, but sometimes that's not always the case. Sometimes we, even our adult children, we don't necessarily want to give assets to directly. So, and that can be for a variety of reasons. So I'm going to go out of sequence here because you just referenced that and say that one of the mistakes that we see pretty often is communication, sitting down with your families and talking about your intention on your estate plan. And I know you all feel that's pretty important, right?
Yes. We call the people that will be involved in administering your plan your helpers. It's kind of an umbrella term. So it could be the financial power of attorney, the agent, a healthcare agent, a trustee, or an executor. Making sure that they know that they have been appointed to do the job, that you've listed them in the document, and that they want to do it. Because if they don't want to do it when they're called upon, if this is a surprise, then we don't have someone to help you when you need it the most. So communicating with the helpers as you're getting your documents in order or revising them and making sure that they know they have the job, that they want to do the job, is very important. If they're going to be able to do the job down the road, that's a different story. They may not
Yeah,
be able to at the time, and that's why we want to have some depth. But communicating with them about what their duties are and letting them ask questions about those
right,
responsibilities
right.
is very important. Sharing some information to your level of comfort about where documents are held, where your assets are held, again, to your level of comfort, but sharing with them so that it is easier process when they have to step into your shoes and help you. They'll know where your bank accounts are versus not knowing where they are and having to go to every bank to find out. It's just more efficient for them and much less stressful for them to be able to do the job you're asking them to do for you.
Yeah, and communicating the detail. Now, the story that I have, though, is a little unique to that. I really have a family where the parents have some priorities before they want assets to go to their daughter. So it's a mom and a dad, two daughters, and a son-in-law. And interestingly enough, the son-in-law is going to be the one who's going to be the successor trustee of their trust. And there's a couple of reasons for this. One is because one of the daughters is divorced and still has a difficult former spouse, and so they're concerned about giving money to her outright. But they also have an education priority that they really want their granddaughters educated before money is distributed directly. But there's also a third feeling about the daughter who he is her brother-in-law, and that is they are not comfortable with her ability to manage money, and yet they're very comfortable with him.
Mhm.
So they haven't sat down and communicated that to their daughters. And so what I said to him, and I think probably the one daughter knows, obviously she's married to the future trustee, but so I said to them, I think it's important to kind of have a family meeting
Yes.
to talk about your priorities. Otherwise, you're putting this poor son-in-law in a pretty tough situation. So
Yes, and the person that has the job oftentimes does have to not only um deal with the situation, if that's, paying bills, making medical decisions, but sometimes there's surprise in the larger family group that this person has been appointed to do this job. And
yeah,
so there's stress that additional stress that comes with it if families aren't aware of who's going to step in and do what when the time comes. We don't want families going through more surprise and more disappointment when we need our helpers to come in and help. We want everybody to understand what's going to happen in advance within reason, and the people that are going to be doing it should be shared with our loved ones.
I mean, I think it really is important because I have seen conflicts come up when people are surprised and estates that are challenged. Because wait a second, I didn't necessarily want to wait. I thought I was going to get my inheritance. This is kind of a surprise to me. And I think that can sometimes encourage challenges to the estate settlement as well. Have you seen that in the past?
Yes, and it's all based in I didn't know. It was a surprise in
Right.
in kind of that feeling that they get that they've been treated unfairly in some way. Whether that's justifiable is another entire
Yeah.
conversation and would have to be dealt with in the court. But you don't want to create situations where someone can contest what you're doing here. We're trying
Exactly.
to make the road pave the road smoothly for the helper that comes in if we're incapacitated and is doing things while we're alive and unwell, and certainly after death they're going to be responsible for administering our estate, distributing our assets. You want to make it as smooth as possible for them. No surprises, no surprises, especially ones that
Right.
can really upset the beneficiaries.
Right. Especially if you can imagine your trust is going to be in existence for a while. So
Mhm.
my priority was educating my granddaughters. That's got to get done first. I'm a little bit concerned about your former spouse. And that can be that can be a reason that even she might disclaim it because she doesn't want it to come to her too. But I think that it's also healthy to just say these were my intentions. If not, just drafting a little letter. If you don't want to do it in a formal family meeting, to draft, what are those called? They're letters where you're actually doing something to the family outside of the will to clarify your intentions.
Yeah, we call those legacy letters.
Yeah.
Sometimes they're instruction letters on certain things, but we call those legacy letters to let the family or your loved ones, if they're not family, and their friends, let your loved ones know you're thinking. And
Yeah.
it's just in your own words, typewritten or handwritten, and keep it with your documents. And I have many clients who do a wonderful job on capturing what they want in ways that we can't really capture in a will or a
In a
trust
document. That's
document.
right.
Yeah.
That's
Even
right.
in some of the other incapacity documents, like the financial powers and the healthcare powers, capturing more than what the documents will allow. There's no right or wrong form here.
Yeah, perfect, perfect. And then that brings us to a fourth one that really just, I think, encompasses everyone, so many people that I work with, and that is your personal circumstances change. And sometimes you don't think about the impact of those changes because we're not thinking about estate planning every single day, but changes in our personal circumstances can dramatically impact our estate planning, right?
Yes, time marches on, things change. It could be just our thinking or our approach for beneficiaries or even for ourselves. Has there been a divorce, a marriage, a child? Is there some kind of unfortunate development that has happened to one of the beneficiaries that an inheritance would interfere with, like an addiction? So,
Yes,
really
yeah.
reviewing things, um, even if it's just in your mind, reviewing things every 2 or 3 years, or taking your documents out and looking at them. Are the people that I want to be involved, either as my helpers or my beneficiaries, right? Has their situations changed? Is there anything that I'm worried about? Has your financial situation changed? Up or down? Have you had an inheritance and now it's completely different than when you did your planning? Um, for a little while, we were concerned about what tax laws might change for 2026 in terms of the federal estate tax. Would that have changed tax planning for some individuals in the future? So, just kind of thinking about your planning, what's changed. If you feel like it's something that you need advice on, reach out for it. But keeping it top of mind so that if something does change, you get it right. So if we've lost someone who's a helper to me, so if I have you, Sally, named as my first healthcare agent, financial agent, and trustee, and you have predeceased me, am I okay with your successor, or do I need to name a
Yeah.
successor if I
Yes.
don't have one? So that's the kind of review. Every 2 or 3 years, just kind of think it through or take a look at your documents.
So it's interesting because we do make this part of our client review process. And sometimes I think you say to people, we're going to review your estate planning every 2 to 3 years. And you're like, well, I don't get it. Why do I need to? And so, but it's so interesting. Clients' lives are pretty dynamic.
Yes.
And so we find reviewing the beneficiaries, just talking about the estate plan one more time every 2 or 3 years. Again, this is what I'm saying. We see our role as just not allowing a mess to accumulate that if we lose a client, that we're going to have to face with their family. So because we take it pretty personally. So it's you're right. I think most people would never think that they should review their estate planning that frequently, but we do find it very constructive in our client reviews. I also have to tell a little bit of a funny story. When you say divorce, that's why I smiled when you said it. A good friend of mine, she's not a client, She and her husband divorced, and he just never took care of the money, in during their marriage. And the one thing he forgot to do was to change the beneficiary designation on his retirement plan. So she received the retirement plans. Now she's the sort of mom that she's going to make sure it gets to her son. So nobody was hurt in this process, but it could be very different in another one. So you do realize that your circumstances change. When they changed pretty dramatically, you need to look at everything on your estate planning, or you could be leaving your money to someone that it wouldn't be your intention, so yeah.
You
Yes.
reminded me, Sally, there's a Vermont case that is essentially that, only in the realm of life insurance. And so $1 million policy, which was intended to go to an individual's spouse, had the individual's second spouse, had the first spouse still named as the
Yeah,
beneficiary on
yeah.
it. And so beneficiary designations, as we said,
They're
control.
important. They
So
really are.
that was a very, I'm sure, uncomfortable and expensive endeavor for them to straighten out. So
Yeah,
that's a good point that you bring up. Reviewing it, making sure
yeah.
that that beneficiary designation is the way you want it to be, or
To be.
get it changed.
And so we're going to come to the fifth one, and I saved this one for last because it's more of your estate planning from a living perspective. And that's, we call it Plan B. And that is, I'm going to stay in my home forever, right? And so I think that's what we all think we'd like to do when we're 50 or 60 or 70, but that's not always the case, is it?
It's not. So we all want to have our A plan play itself out. But if it doesn't, because of illness or a change in financial circumstances, we need to have thought through our B plan. So if my A plan is I want to age in place in my own home, if I can't, because I have advancing dementia and I am going into second and third stage dementia, it's not going to be safe or reasonable for me to be at home in most circumstances. So, knowing where you would like to be or prefer to be, look into that. Um, I, if that happens and I can't be home, whether or not I have dementia, I have looked at this facility and I do like it there. Maybe I get on the wait list for it, because some of the wait lists are years long, believe it or not. Touring them weeds out the ones that you don't like and the ones that you do like, and allows you to um, plan for that. A lot of what we do in estate planning is we're planning for the future and a lot of unknowns. And one big unknown is, am I going to be healthy enough to live on my own for the rest
Yeah,
of my life?
absolutely.
And
Absolutely.
am I going to be able to afford it?
Right.
So
That,
that's part of
yeah,
you weave into
yeah,
this. And so we're trying to kind of look into a crystal ball and predict the future, both with documents and what your wishes are in terms of where you're in your finances too. We want to have, yes, this is what I want to have happen, but maybe a B plan. Not maybe, definitely a B plan, and maybe a C plan there too.
right, right,
Worst case scenario, this is where I would be. So think kind of outside the box there in terms of ultimately what my goals are. If they don't happen, especially with my living arrangements, as I'm thinking about my longer term planning, as we call it, where am I okay with being if I'm not at home?
no, and it's really, really true. And I think that what we try to do is to encourage folks to look at it sooner than they probably think they should. And I'm going to tell one story of a client of mine. She was actually coming to see me that day, and she was very confident she was going to live in her home for the rest of her life. But she backed out of her garage, and for whatever, I don't know what happened, she ended up going right into the side of her neighbor's garage. Now, she ended up coming to see me anyway, which I was stunned because, the car, her little bumper was off and all this kind of stuff. But she gradually came to the conclusion that she couldn't stay at home because she lost her confidence just in her ability to drive. So it
Mhm.
wasn't even any sort of loss of mental faculties.
Yeah.
But because she couldn't drive, then going to the grocery store, we live in a pretty rural community, don't we? Getting around and taking care of ourselves becomes difficult. So she was a single woman, no children. And so she ended up understanding she needed to go to an assisted living facility. But she had a brother that she had been estranged from for about 10 years. She had a sister who lived very far away. By the grace of God, she had two very close friends who literally, she took care of them when things were tough for them at some point. So they agreed to take care of her. But it really was late. She was well through her 70s. And so one of the questions we have is financially, how is this going to go for her? Because if she does somehow run out of money, and it is a possibility, it is a possibility. It's not going an impossibility. We're dependent on a brother that we didn't maintain a very good relationship, or with a sister who's pretty far away. So we reviewed her power of attorneys, her financial, as well as it was better to have the closer people. But it became very confusing because I'm trying to help her, and she's choosing people outside of the family to take the authority. And so I think you and I even talked about this case. I was a little concerned about my responsibility in it, but more importantly, that's kind of what late planning does. So
Yeah.
we try to, it puts you in a position where you need to react versus a proactive position. So we really try to talk to our families who are in their 50s to
Yeah.
say, let's just imagine this, because now I've got clients who are old enough that to me, it's not a question of whether. It's just if you live long enough, it's a question of when might you need assistance. So putting your plan B together isn't something you wait until you're in your 70s to do it. You should really think about it when you're doing your estate planning. I think in your 50s is our experience, because you have more options available to you, right?
I think that's an excellent point. Proactive planning, you have a lot of options usually. Reactive planning, especially if we're reactively planning because of a health issue,
Yeah,
most of the time there are less options.
yeah,
So I think that's an excellent point to make. I mean, what we're looking to do here, right, for our clients is kind of take good care of tomorrow. That used to be one of my law
yeah.
firm's kind of mottos: take good care of tomorrow, or smooth transitions into incapacity, into death, into someone stepping into our shoes and helping us. That's what we're doing by looking at all of these issues and encouraging our clients to get their advisor teams all on the same page so that we can all help them accomplish those goals.
No, and it's true. And you started us out with this, how it's important to bring all of the people together, your attorney, your accountant, your insurance person, your financial advisor, bring them all on board so that they understand the different implications of what your estate plan might mean, given their role in your financial life. So yeah.
And it's been my experience, and I shared this with you, that clients share different bits of information with different advisors. It just depends on the topic. So I have often found that the financial advisors have so much valuable information on families, on background, on client thinking than I could ever get in working with them on documents. So a financial advisor being involved in the mix is, for me, very helpful to help the client, because you have so much valuable information that you can bring to the table to help me accomplish my bit in creating the documents for them.
Yeah, and I think that's why we take it so because you're absolutely right. It's our role is to be in continuous communication with them over so many different things that we do have the occasion to understand the more intimate things that they're concerned with. So yeah, so but it's just important. I think everyone has a very important role in the estate planning piece to avoid these mistakes. That's the goal here. So,
That's right.
well, Renee, thank you. I really appreciate your time and
Thank
your
you.
expertise on
I've
this. And
enjoyed this.
yeah, and I have a feeling folks will find it helpful. So thanks for your time. And
Thank you.
yeah, we look forward to working together again.
Absolutely.
Take care.